Based on what we saw in court yesterday, applicant number 4, Gwabeni, the one who received the 800,000 rands, the Gcaba brothers, or should I say one of the Gcaba brothers. And I'm here to say, I'm not saying he's innocent, but I'm here to say his case the defense that his lawyer read out in his affidavit is literally, in my opinion, I would say strong enough for him to get bail. The state failed to prove his ties with the bodyguard, for example, and the other 4 accused, including the 2 brothers in Eswatini. The state also failed to show that there were other transactions, as accused number 4's lawyer alleges, that this is not the first time that there's been transactions between Gcaba brothers. So, and not only that, I think it was a brilliant move for Gwabeni to say, if you're saying I'm the mastermind and I got 800,000 rands, and I got 800,000 rands from one of the Gcaba brothers, why is the Gcaba brother not seated right next to me over here in the dock? And you know what? That's a fair question. Why? Because one of the Gcaba brothers issued a statement and told us that we haven't even spoke to the state, okay? We are not guilty of anything because the state hasn't even come to us. And for that reason, I knew when that statement was released and it was revealed that they hadn't been questioned in the least bit, that was going to get Gwabeni off the hook. Your thoughts, Mzansi? Let me know in the comment section down below. Should Gcaba brother also be seated in the dock? Quite frankly, as you know, you are innocent until proven guilty. I'm a little bit disappointed with the state, and here is why. Accused number 4, Gwabeni, was able to break down everything in terms of what he's being accused of by the state and how it does not tie him to the AKA case. The state did not show us any motive. Well, in the state's defense, the other thing is that the state has not put everything on the table, because the state is saying this is not a trial. This is literally just a bail application. And just based on the bail application, not everything that they're being accused of or the evidence is on the table. For example, he's just being associated with the location of the airport because his phone pinged there, and also because he used his virtual card to pay for the parking at the airport. And accused number 4 is saying, how many kilometers was I within this radius? You're not giving a breakdown. You're not giving us a clue. Was it 10 kilometers, 5 kilometers, 100, 1,000? What exactly was it? And you know what? In all fairness, I have to agree with applicant number 4. I think as well, when the state presented the case, we were all just shocked and gobbling up everything that they're saying. But if you listen to the detail that accused number 4 is saying, the state doesn't have a strong case for now, because we don't have all the facts at hand, including applicant number 4 doesn't have all the facts at hand. One part that happened is that accused number 4's lawyer said, my client is able to prove that this is not the first transaction between my client's company and the Gcaba brother. It's nothing new. It's nothing new to shout about. And then the state says, well, we didn't have access to your client's statements between January and February. And then the lawyer responds back and says, that's not my responsibility to provide you with that information. You need to subpoena the bank and they'll be able to give you all the information that you need, which is actually true. So the state is relying on the accused to provide bank statements that will prove them innocent, yet the state needs to prove them guilty. I hope you understand what I'm saying here. But let's listen to this witness's affidavit in detail so that you can also hear for yourself that the state's case is not as strong or as airtight as we wanted it to be. Will he be granted bail? Let me know in the comment section your thought on that. What are your thoughts on that? Do you think that the state presented a very strong case, or did applicant number 4, Gwabeni, present a stronger defense than what the state is accusing him of? And also, yeah, pretty interesting. I'll be back with the rest of my commentary because I also want to talk about the wives. Yes, there's 2 wives.
Thank you. Thank you. This is the replying affidavit of applicant number 4. I, the undersigned, Mzansi Harvey Gwabeni, do hereby make oath and state. I've read the affidavit deposed to by Kumarasan Pillay and respond thereto as set out hereinunder. A critical reading of Pilley's affidavit should, I believe, lead the reader thereof to the conclusion that the state's case against me consists of the investigating officer taking bits and pieces of evidence which he believes is suitable to his case, joining them together with his own theories, and thereafter presenting them to this court. In so doing, he has attempted to mislead this court and has departed from his duty as an investigating officer to investigate objectively by leaving out evidence favorable to me. The immense problem that the state has in this matter, and which can be described as the elephant in the room, is the status of Gcaba and the failure on the part of the state to arrest him. The state has alleged that I am the mastermind behind the killing of Kiernan Forbes, aka, and Tabela Mutswana, and that an amount of 800,000 rand, which was transferred into my account, was payment for the so-called hits. The state has alleged that the transferring of the funds was payment for the shooting. In this regard, paragraph 71 of Pilley's affidavit refers. According to company records, Mr. Sidney Gcaba is the sole director of this company. When the money was transferred, a reference was used as consult. This, we are of the view, was done to disguise the nature of the funds, as same is viewed to be payment for the shooting. If the state honestly believes this, and if it had any evidence, not conjecture, then I would have expected that Gcaba would have been arrested and would have been a co-accused. The fact that he is not a co-accused and the state has not taken this court into his confidence and disclosed why they have chosen not to arrest him.
It was literally at this moment, as well as last week, when the statement was issued by the Gcaba brothers, that I also asked the same question. Why haven't they been arrested or questioned? And it was at this point that, I believe that Gwabeni will be granted bail, just based on this little technicality. And even during this bail application, the state did not respond. They did not respond to that accusation. Because guess what? We want to know. Why is one of the Gcaba brothers going around transferring 800,000 rands and then the reference being consultation? And that's another piece. For the reference to be consultation, think about it. When you are transferring money or doing an e-wallet, you're the one who's writing the reference. You, the one who's sending the money, is the one writing the reference. It is not Gwabeni. So does Gwabeni deserve to be seated in the dock because he received money? And his only charge is for money laundering. But let's listen on and hear how this lawyer and hear how his defense lawyer is going to get him bail. And that is what I believe. Let me know in the comment section if you agree.
As I've stated in my founding affidavit, I'm involved in the coal mining industry and consult to various parties. The reference accompanying the deposit of 800,000 rand into my account, namely consult, is corroboration of this fact. It is not the function of this court to simply rubber stamp that which the state desires, and in fact, the law, when it comes to bail applications, encourages a presiding officer to adopt a more inquisitorial manner. As such, I believe that the question this honourable court should be asking is why exactly has the state failed to arrest Gcaba? I submit the answer to the said question is because there is no evidence against him, save for the payment of 800,000 rand into my account for services that I rendered to him. Just as the state has been unable to tell this honourable court what possible motive I could have in the killing of Forbes, so it is, and that the state cannot inform this honourable court why Gcaba would want Forbes and his companion killed. The reason for this is simple, and that is that neither of us are contract killers or wish to see them dead. I addressed those aspects of Pilley's affidavit that deserve attention hereunder. At para 9. Pilley alleges that I was at the airport and that I used my phone to pay for parking using a virtual bank card. If he had investigated properly and objectively, he would have noted that my wives and those who do work for me are also in possession of a virtual bank card linked to my account. A virtual bank card and the allegation that I was at the airport around the same time is simply insufficient. It is insufficient, and it is also based on cell phone triangulation, which at best puts an individual within a 10-kilometer radius of any particular object or building. The state has been strangely silent and has chosen not to address the fact that an airport is a national key point with extensive security and closed-circuit cameras. As such, had I been the driver of the grey BMW on the day and time in question, I would have expected the state to state categorically that they have video evidence of me driving the motor vehicle and following Forbes. The fact that they have not stated this is an indication that they have no evidence that I was driving the grey BMW or even in the said motor vehicle. As I've stated from the onset, it is no secret that I was in possession of the grey BMW as well as the grey VW Polo. It is alleged that, upon further investigation and using cellular phone records, it was established that applicant 4 was present in the grey BMW that had followed the first deceased and his entourage to the hotel. The state does not take this honourable court into its confidence and disclose the investigation, and its vague reference to cellular phone records can only but mean cell phone triangulation. This on its own is insufficient, and I'm advised that there is case law which comments critically upon the reliance of cell phone records. Ad para 18. Although the purpose of my deposing to this affidavit is not aimed at defending my co-accused, it is necessary to point out certain allegations which I believe are indicative of Pillay wanting to mislead this honourable court. An example of this is that the clothing of the person that alighted from the vehicle and entered the restaurant was the same as seen in the video footage as being the African male that was later identified as applicant 5. It is significant that Pillay does not describe the clothing other than a vague reference to it. An example of this is 2 individuals who both wear long pants and a long shirt. They would be seen to be having the same clothing, according to Pillay. Ad para 26. Another indication of this is the allegation that one of the suspects who attempted to set the Mercedes-Benz alight purchased airtime from a tuck shop a few meters from where the vehicle was abandoned. This honourable court is not informed as to the date upon which the Mercedes-Benz was allegedly attempted to be set alight, as well as the date upon which one of the suspects allegedly purchased airtime. Ad para 27. Once again, reliance is placed in cell phone triangulation, and the allegation is made that I was in the vicinity of Florida Road at the time of the shooting. Whilst I cannot recall my exact whereabouts, Florida Road is considered one of the premier night spots of Durban, with notable restaurants such as Zai, El Cubana, and Duka. Importantly, Pillay does not share with this court exactly what he means by in the vicinity of Florida Road. And by that I mean nowhere in his affidavit does he state where the cell phone records place an individual 5 meters, 50 meters, 100 meters, 500 meters, or even 1,000 meters away from any particular spot. The investigating officer adopts a similar modus operandi in respect of other geographical places in which he relies on virtual cards without ever having investigated how many individuals were issued with the virtual card or how accurate the cell phone triangulation is. Instead, he prefers to rely on in the vicinity. Ad para 31. Once again, the state relies upon the fact that applicant 1, 2, and 5 were placed in the vicinity of my home on 11 February 2023. In this regard, I deny that they were with me, but I was most certainly at my home. I cannot comment on what applicant 1, 2, and 5 were doing or where they might have been. In this regard, it is significant that the other applicants have been charged with various offences in their own capacity or where they are linked to each other. That they knew each other and may have been participant in other activities, I am not in a position to deny, as I do not know. Importantly, I have not been charged with any other offence besides this one. This is significant in that Pillay has alleged that the applicants are a gang and are available for hire. This is not, even on the state's version, the evidence before this honourable court. Ad para 33. I note that Pillay has elected to attach a table, Annexure KP1, to his affidavit, rather than simply attaching the actual bank statements, which would give this honourable court a proper insight to the passage of monies into and out of my account. Ad para 38. Pillay once again jumps to conclusions when he alleges that I gave instructions for the disposal of the vehicle, referring to the grey BMW. This is a distortion of the truth in that I did not dispose of it in the sense of wanting it hidden, as Pillay wants this court to infer. Ad para 48. Yet another example of Pillay not wanting to take this honourable court into his confidence is his reference to the raiding of my home. He states, entry was gained in a lawful manner as usually used when looking for suspects in order to arrest. What does this mean? He does not take the court into his confidence, and describe exactly what occurred, and that is that heavily armed policemen forcibly gained entry into my home, and this was unnecessary. In this regard, I annex here to marked GR1 video footage of the said raid. And, Your Worship, I understand that that is in the USB attached to the brown envelope. The actions of the SAPS are particularly alarming when it is alleged that a member of the SAPS team apparently spoke to me personally on 26 February 2024. See paragraph 207. At paragraph 118, Pillay states that there is evidence suggesting that the applicants operated as a gang that were hired to kill people as hitmen. Yet again, he does not take this court into his confidence and disclose what that evidence is. But the fact of the matter is that although he mentions that the applicants are at present facing, Your Worship, 12 counts, I am not. Once again, he does not disclose to this court why he has not arrested Gcaba, more especially in light of his theory that I was hired to kill people as part of a gang of hitmen. Add paragraph 119. As stated herein above, yet another example of the vagueness and smoke and mirrors that the state has brought to this investigation and this application is the following statement on the part of Pillay. There is an element of evidence suggesting offences committed under gang-related activities. The state is collecting evidence to substantiate these charges. It does not explain what an element of evidence is, which suggests offences, but simply states that the state is collecting evidence to substantiate these charges. The inference to be drawn is that this is yet another theory lacking in evidence. Similarly, the statement that there is evidence suggesting that there were discussions falls into the same category. Add para 136. The state has alluded to money laundering and the proceeds of crime.
And there you have it. Just a defense statement where he goes on and on and on, mentions several times Gcaba has not been arrested. Why is he also not here to answer for why he transferred me that money? Why are we not co-accused in this conspiracy theory that this investigator is building, because it is not based on fact? It is just a theory that he's trying to sell.
The immense problem that the state has in this matter, and which can be described as the elephant in the room, is the status of Gcaba and the failure on the part of the state to arrest him.
And I don't know anything. In fact, I don't even know these other accused. I don't know them, okay? Even if you have them near my house on the 11th of February, which is a day after AKA and Tibz were murdered, he is saying, I don't know them, okay? I do not know them. So therefore, you cannot say that I'm associated with them just because they were near my house. I wasn't with them. Which for me was like, oh wow, the state has an uphill battle here. But as well, he mentions as well that he needs bail because it's not true that his wife is a doctor and therefore she can handle the bond payments. You need to understand, in any relationship, bills are split. She might be a doctor, but that's the bill that we agreed that she pays. But I have other responsibility as well. For example, I have a second wife, and my second wife is a student. She's unemployed. Now, you have to wait for this. Remember, his first wife is a doctor. His second wife is a student, okay? She's learning to become a what? An advocate. I mean, you know what? I don't want to knock down another person's hustle, but yeah, that was a very interesting point to me. Let me know what your thoughts are on the two wives' professions. Is it strategically placed? Or is it just a coincidence? Anyway, both wives, okay, 1 and 2, wrote affidavits confirming that, hey, they agreed to everything that he has said about them to be true, okay? They're not agreeing to the crime or anything else. Just anywhere they reference, whatever he says, it is true. Yes, I'm wife number 1, and yes, she's wife number 2. Okay. Now, it certainly has got interesting. He doesn't just have one wife as an alibi. He's got 2. Okay, Mzansi, well, we have to wait until the 2nd of March for the verdict of this. I think even for them, they were quite disappointed because that means more time for them behind bars. Well, that's it from us, Mzansi. In our next video, we will break down accused number 3's defense and why he thinks he deserves bail. But, you know, that's a whole other ball game. That's it from us today. We want to hear from you. Make sure you join the conversation in the comment section. Let us know your thoughts. Are these the guys who killed AKA and Tibz? Comment down below and we'll catch you on our next upload.